Senator Kennedy asked Bondi point blank if someone killed Jeffrey Epstein. She had one answer. The question arrived after the anomalies had been established. Senator John Kennedy had been methodical throughout the hearing. He had walked through the Strzok and Page settlement. He had pressed for the name of the FBI official who suppressed the Hunter Biden laptop story. He had gotten answers or the absence of answers and recorded both. By the time he reached Jeffrey Epstein, the room understood his technique. He builds a foundation before he asks the question that the foundation makes unavoidable. He does not arrive at the dramatic moment. He constructs it. On August 10th, 2019, Jeffrey Epstein died in a federal jail cell. He was the most consequential federal prisoner in the country at that moment, awaiting trial on sex trafficking charges that would have required him to testify under oath about the people connected to his operation, a trial that would have produced, for the first time, sworn testimony from the man at the center of the network, testimony about who participated, about who knew, about the relationships and transactions and events that the federal investigation had spent years documenting, a testimony that would have been, by any reasonable assessment, the most significant witness account in the history of federal prosecutions of elite criminal networks. He died before that trial happened, before that testimony was taken, before any sworn account of who knew what, who was present where, who was connected to what, could be placed in the permanent record. He died, and the official determination is suicide. And the four things that coexist with that determination, the cameras, the guards, the logs, the forensic findings, are what Kennedy was building toward before he asked the 6 words that are now in the permanent record. This channel tracks the documentation as it moves through the legal system. If you want to follow where this goes, subscribe and turn on notifications. New videos drop when the record produces something worth documenting. Let's start where the documentation starts. The first documented anomaly is the cameras. On the night of August 9th into August 10th, 2019, the security cameras covering the area outside Jeffrey Epstein's cell at the Metropolitan Correctional Center in Manhattan were not functioning. This is a documented fact established through court filings and Inspector General reports. Not a rumor, not a claim from an interested party. A documented finding from the official investigation into how a federal prisoner died in federal custody. The Metropolitan Correctional Center is a federal detention facility. Epstein was housed in the Special Housing Unit, a high-security area for inmates who require heightened oversight. The security camera infrastructure in that unit is not a supplementary system. It is a primary mechanism of institutional accountability. Cameras document what happens in areas where direct human supervision is intermittent. They produce a record that can be reviewed, subpoenaed, analyzed, and preserved. When a high-profile prisoner dies under contested circumstances, the camera record is often the most important documentary evidence available. The cameras outside Epstein's cell were not recording when he died. The explanation that emerged through subsequent investigation was equipment malfunction, a technical failure that coincided with the night in question. Whether that explanation is complete, whether the investigation into the malfunction examined the possibility that the failure was deliberate rather than accidental, is a question that the documentary record does not fully resolve. The FBI's investigation had access to the camera maintenance logs, the technical specifications of the system, and the pattern of prior malfunctions. Whether the investigation made a documented determination about whether the failure was consistent with equipment breakdown or inconsistent with it has not been fully disclosed. The cameras weren't recording. The night Epstein died, the cameras covering his cell, not functioning. That is the documented fact. It is not disputed. It is not a claim from an attorney or an advocate or a family member seeking a different outcome. It is a finding from the official investigation, documented in Inspector General reports, cited in court filings, acknowledged by the Bureau of Prisons. Why they weren't recording is the question that has not received a fully documented answer. The official explanation, equipment malfunction, is not impossible. Security camera systems fail. They require maintenance. They have technical vulnerabilities. A malfunction on any given night at any given facility is not inherently suspicious. But the relevant question is not whether the malfunction was possible. The relevant question is whether the investigation examined the full range of explanations for the malfunction and documented its conclusions. Whether the technical logs were reviewed, whether the maintenance record showed prior failures at that specific location, whether the failure pattern was consistent with random equipment breakdown or inconsistent with it. Those are documentable questions. Whether the investigation's answers to those questions have been released is part of the working through it. The second anomaly concerns the guards. On the same night, the two guards assigned to check on Jeffrey Epstein every 30 minutes were both asleep simultaneously. This is not merely a disciplinary matter. Failing to perform required welfare checks on a federal prisoner who subsequently died is a federal crime. One the guards admitted to, and that was addressed through plea agreements. But the institutional accountability process produced outcomes, not a complete explanation. What it did not produce was a documented account of how both guards assigned to the most consequential federal prisoner in the country came to be asleep simultaneously. On the same night, the cameras were also not functioning. Two guards, same shift, same night, both asleep at the same time. A single guard falling asleep is a documented failure. Both guards assigned to the special housing unit falling asleep simultaneously in a facility where Epstein was among the most closely watched prisoners in the federal system is a coincidence whose significance the investigation documented without fully resolving. The third anomaly is the logs, and this one crosses from negligence into criminal territory. The guards did not merely fall asleep, they falsified the records. The welfare check logs for that night showed entries indicating that Epstein had been checked at regular intervals. Those entries were false. The guards had not performed the checks. They had recorded checks that did not happen, creating a paper record of supervision that did not exist. This is not a paperwork error. It is not a rounding correction or an imprecise timestamp. It is the deliberate creation of a false federal record, a document that states something happened when it did not happen in a facility operating under federal law that makes the falsification of official records a prosecutable offense. The question the falsification raises is not complicated. Records are falsified to conceal. The standard question in any investigation involving falsified records is, what was the falsification designed to conceal? In this case, the falsification concealed the fact that the guards were asleep and not performing their duties. That is what the official investigation concluded. The falsification hid negligence, whether the falsification was designed to conceal a negligence, or whether it was designed to conceal something that negligence was designed to enable. That question has not received a documented answer. It is not a speculative question. It is the investigative question that any serious inquiry into falsified federal records would ask. Whether the FBI's investigation asked it and what the investigation found is part of the documentation that remains working through it. The logs were falsified. The guards wrote down checks that did not happen in a federal facility, in the special housing unit, on the night Epstein died. The official explanation is that the falsification concealed negligence. The guards fell asleep, knew they had violated their responsibilities, and created false records to obscure that violation. That is the explanation the official investigation accepted and the one that informed the criminal accountability process for the guards' conduct. The question of whether that explanation is complete has not been closed. The investigative logic of record falsification generally asks two questions. First, what did the falsification conceal? Second, was the falsification designed to conceal only what was immediately visible, or was it designed to conceal something that would not be visible without the concealment? In this case, the falsification concealed the absence of welfare checks. That absence is consistent with guards who were asleep. It is also consistent with guards who were awake, but not performing checks for a different reason. Whether the investigation examined the second possibility and documented its conclusions is part of the record that has not been fully disclosed. Three anomalies: the cameras, the guards, the falsified logs, each documented, each unresolved. Then the body itself produced a fourth. The fourth anomaly is forensic, and it comes from one of the most credentialed pathologists in American legal history. The medical examiner's initial report listed the cause of Epstein's death as pending. The final determination, issued by the New York City office of the chief medical examiner, was suicide by hanging. Dr. Michael Baden examined the body independently, retained by Epstein's brother. Baden is not a fringe figure. He is one of the most credentialed forensic pathologists in the United States, a former chief medical examiner of New York City, a former chairman of the House Select Committee on Assassinations Forensic Pathology Panel, a physician who has been involved in some of the most significant forensic examinations in American legal history. His professional standing is documented and uncontested. Baden's findings differed from the official determination. He identified fractures in Epstein's neck, specifically fractures of the left hyoid bone and the thyroid cartilage, that he said were more consistent with homicidal strangulation than with suicidal hanging. He was specific about the anatomical basis for his interpretation. The hyoid bone fractures in particular, he said, occur more frequently in cases of manual strangulation than in suicidal hangings, because the mechanism of force is different. Manual strangulation produces a different pattern of neck injury than the weight-bearing suspension that produces death in a suicidal hanging. The official medical examiner's conclusion and Baden's conclusion are different. Both are documented. Both are based on the same physical evidence. They reach different conclusions about what that evidence indicates. The FBI's investigation had access to both determinations. The investigation also had access to Baden directly. He was available for consultation and stated publicly that he had not been contacted. Whether the FBI's investigation formally addressed the discrepancy between the official finding and Baden's finding and what the investigation concluded about the significance of that discrepancy is part of the documentation that has not been fully disclosed. This is not a conspiracy theory. It is a documented medical disagreement between two forensic pathologists of professional standing about the physical evidence in a death investigation. Medical disagreements about cause of death are resolved through documented investigative processes, additional examinations, peer review, documentation of competing interpretations. The question of how the FBI's investigation handled the discrepancy between the official finding and Baden's finding is a specific and documentable question. It is part of the working through it that the documentation has not yet resolved. The official determination says suicide. A forensic pathologist of established standing examined the same body and reached a different conclusion. Both of those facts are in the record. They have been in the record since 2019. They sit alongside each other in every public discussion of Epstein's death without having been reconciled. The official investigation was conducted. It reached a conclusion. A credentialed independent examiner conducted his own review and reached a different conclusion. The standard investigative response to that kind of disagreement is documentation, a formal record of how the discrepancy was evaluated, what additional evidence was considered, and why the official determination was upheld notwithstanding the independent examiner's contrary findings. Whether that documentation exists and whether it has been released is part of the working through it. Now the 6 words. The cameras weren't recording. The guards were asleep. The logs were falsified. The forensic findings disagreed. Kennedy had been building toward one question. 4 anomalies, all documented, none fully resolved. After all of that, the cameras that weren't recording, the guards who were simultaneously asleep, the logs that were falsified, the forensic findings that reached a different conclusion than the official determination. Senator Kennedy looked at the Attorney General of the United States across the hearing table and asked the question that 4 documented anomalies make impossible to avoid. Did Jeffrey Epstein hang himself, or did somebody kill him? Bondi had been managing the hearing with the controlled precision of someone who had prepared for a difficult session. Her hands had been still on the table. She had been meeting questions with direct eye contact, with institutional composure, with the specific discipline of an official who understands that everything said in that room is on the record. She had been managing. Then Kennedy arrived at 6 words. Her eyes moved briefly off him. The involuntary fraction of a second that happens when someone is retrieving a prepared answer rather than forming a spontaneous one. Her hands, which had been flat and still, came together on the table. Then she looked back at Kennedy. She said he hung himself in a cell. The room held, not the theatrical pause of a proceeding built toward a dramatic moment. The actual stillness of people who understand that a yes or no question has just been answered by the person legally responsible for the answer, and that the answer, whatever its relationship to the 4 documented anomalies that preceded it, is now in the permanent record. Kennedy wrote something down. He did not move on. He asked, "Are you going to release all the information about that?" Bondi said they were working through it. He asked, "When?" The pause before that answer was the pause of a specific internal calculation, not hesitation about the answer. Calculation about what commitment is safe to make in this room, on this record, about a timeline that the department has not established. Bondi looked briefly at the papers in front of her, not reaching for them, just the reflexive downward check of someone confirming that what they are about to say is consistent with the position they prepared. The pause of someone who understands that naming a date creates an obligation and saying nothing creates a different problem. She said, "In the near future." Kennedy said, "Like before I die?" That question landed in the room with the specific weight of someone who has been listening to the same answer for years and has decided to name what the answer actually produces. is. Kennedy is 73 years old. He has been in the Senate since 2017. He has been asking about Epstein's death documentation since the night in 2019 when it happened. He has watched every near future arrive without the documentation it was supposed to carry. He asked the question with the specific weariness of someone who has mapped the distance between near future and actual future and knows exactly how long that distance has been growing. Near future is a phrase with a specific institutional history in this investigation. Every official who has been asked about the Epstein disclosure timeline has reached for some version of it. Forthcoming, working through it, soon, near future. The phrase functions as a commitment without a commitment. It acknowledges that the documentation exists and will eventually be released while providing no mechanism by which the release can be compelled or the timeline evaluated. It transforms an accountability question into a process question, and process questions have no deadline. Kennedy has been receiving near-future answers since 2019. 5 years. Same answer. Different officials. Same phrase. Now let's examine what working through it means. It means the documentation exists. If the documentation did not exist, the answer would be different. There is nothing more to release. The record is complete. We have provided everything that exists. Working through it is a concession that there is something to work through. There are documents in federal files about the camera malfunction, about the guard's conduct, about the log falsification, about the forensic investigation, about the discrepancy between the official finding and Baden's findings. And those documents have not been released. The decisions being made about what to release and what to withhold are being made by the Department of Justice under Bondi's leadership, without a public timeline, without congressional deadline enforcement, without independent oversight of the process by which the determinations about relevance and producibility are being made. That process is being conducted by the institution whose own performance is documented in the files it is deciding whether to release. That is not a neutral process. It is an interested one. Bondi said they were doing it in a way that protects victims and doesn't put irrelevant information into public circulation. The first half of that formulation is defensible. The statute governing Epstein file release authorizes, in fact requires, redactions for victim identifying information. The survivors of Epstein's trafficking network have legal rights to privacy. That protection is legitimate. The second half is the half Kennedy was pressing. The determination of what is irrelevant is being made by the institution whose conduct the documentation examines. The Department of Justice is deciding what documentation of its own investigation is relevant enough to release. That determination, made internally without independent review, without a congressional timeline, without public criteria for what constitutes irrelevance, is not a neutral administrative judgment. It is a choice. And the choice of what is irrelevant is the choice of what the public will not see. A court can determine relevance. A congressional committee can determine relevance. A special counsel can determine relevance. The institution whose performance is under review should not be making that determination unilaterally, when the same institution that conducted an investigation also decides what documentation of that investigation to release. The accountability process has a structural problem. The documentation most likely to reveal institutional failures is being evaluated by the institution those failures would implicate. Kennedy asked when. Bondi said near future. He said, like before I die. That question is 5 words. It contains 5 years of near-future answers compressed into the specific language of a senator who has been asking the same question since 2019 and watched every answer defer the documentation to a future that has not arrived. The question was not about mortality. It was about accountability, about whether the documentation of what happened in a federal jail cell on August 10, 2019 will arrive in a context where it can still produce accountability, or whether it will arrive after the people and institutions whose conduct it examines have moved beyond the reach of the proceedings where accountability is possible. Bondi's answer did not resolve that question. It deferred it. No timeline. Working through it. Near future. The 4 anomalies are still in the record. The cameras, the guards, the logs, the forensic disagreement. Each one documented, each one producing a question that the official determination does not fully answer. Each one part of the working through it that the documentation has not yet resolved. 5 years, 1 senator, 6 words, the cameras, the guards, the logs, the bone fractures, the discrepancy between the official finding and the independent examiner's findings, the The documentation of how those anomalies were investigated, what conclusions the investigation reached, and whether those conclusions are supportable. That documentation is in federal files. It has been in federal files since 2019. It is what the working through it is supposed to be working toward. Kennedy asked when. Bondi said near future. The documentation is still coming, or it isn't.